This is Barry Zalma speaking for Zalma on Insurance, a blog on insurance. Today I'd like to talk about how a insurance criminal expressed chutzpah by admitting to have committed insurance fraud and then claimed that the insurance fraud exclusion in his policy was ambiguous, even though he was convicted of the crime of insurance fraud. He still sought UIM, or underinsured motorist coverage. Chutzpah is a Yiddish term meaning unmitigated gall, where, for example, a defendant convicted of murdering his parents asks for clemency because he's an orphan. Kevin Muir made a claim for uninsured motorist benefits after being injured in an auto accident that fit the definition of chutzpah perfectly. His insurance company denied the claim because Muir had admittedly previously made fraudulent statements in an effort to obtain personal injury, or PIP, protection benefits related to the same accident and was convicted of a crime relating to the claim. Although the policy, like almost all insurance policies, excluded claims related to fraud, Muir still sued the insurance company after he denied his claim, contending that the fraud exclusion was ambiguous. The insurer filed a motion for summary judgment, and the district court dismissed Muir's lawsuit. In Kevin Muir v. Cincinnati Insurance Company, a June 24, 2022 decision of the Court of Appeals of Utah found that the exclusion was clear and unambiguous. Muir is listed as a covered driver under an auto insurance policy issued to him by Cincinnati Insurance Company. The policy provided several types of coverage, including liability, personal injury protection, uninsured or underinsured motorist, and collision coverages. In 2017, Muir was riding as a passenger in a vehicle that was rear-ended by another vehicle. Muir suffered injuries and received $25,000 in damages from each of the two drivers' insurance companies, amounts that represented the policy limits of those two policies. Cincinnati also paid out PIP benefits to Muir under the policy. In connection with his PIP claim, Muir stated that he was not working due to his injuries that he had sustained, but his statement was false. Muir was, in fact, working as a self-employed truck driver. As a result of his false statement, Muir was charged criminally with insurance fraud and entered no contest pleas to reduce Class A misdemeanors. Muir subsequently made a demand for UIM benefits under the policy. However, Cincinnati denied coverage, relying on the policy's fraud exclusion, which reads, quote, "We do not provide coverage for any covered person who has made fraudulent statements or engaged in fraudulent conduct in connection with any accident or loss for which coverage is sought under the policy." Following this denial, Muir sued Cincinnati for breach of contract and breach of the duty of good faith and fair dealing. The parties filed cross motions for summary judgment on the question whether the policy's fraud exclusion precluded Muir's claim for UIM benefits. The district court, based apparently upon the fact that he was convicted of a crime of fraud, granted Cincinnati's motion and denied Muir's. Muir claimed that the policy's fraud exclusion was ambiguous and asked the court to construe the ambiguity in his favor. The Court of Appeals noted that an insurance policy is merely a contract between the insured and the insurer and is construed pursuant to the same rules applied to ordinary contracts. An insurer may exclude from coverage certain losses by using language which clearly and unmistakably communicates to the insured the specific circumstances under which the expected coverage will not be provided. The policy contains a fraud exclusion that bars coverage when a claimant makes a fraudulent statement in connection with any accident or loss for which coverage is sought. Muir acknowledged that he had made fraudulent statements in securing PIP benefits in connection with the accident in question, but argued that those fraudulent statements should not negate his claim for UIM benefits. The fraud exclusion is contained in the general provisions section of the policy, not within any specific coverage provision, so the exclusion is applicable to all types of coverage provided by the policy. The inclusion of the word accident in the fraud clause links the misrepresentation to the accident in question, not just to coverage sought, and makes Muir's preferable reading of the provision unreasonable, especially given Muir's admission that his fraudulent conduct was indeed connected to the accident at issue. The accident for which Muir sought UIM coverage is the same accident for which he made fraudulent statements in seeking PIP coverage, and the policy precludes coverage sought in connection with any accident for which a covered person has made fraudulent statements. The Court of Appeal, therefore, agreed with the District Court's determination that Cincinnati was, as a matter of law, within its rights under the policy to deny Muir's claim for UIM coverage. This case teaches, in my opinion, that there is no such thing as a small or inconsequential fraud. The fraud language of the policy was clear and unambiguous as it applied to the entire policy. Muir succeeded in his PIP claim when he worked to defraud Cincinnati and was convicted criminally of the attempted fraudulent claim. His chutzpah in seeking UIM coverage under the same policy where he was, because of his fraud, PIP benefits, was unmitigated and not worthy of a lawsuit, let alone an appeal. And Cincinnati, in fact, should have received a recovery of the amounts they paid him under the PIP part of the policy because his fraud voided that claim. This video was taken from my blog posting and is available at zalma.com/blog. And you should subscribe to the blog to learn of all future blog postings. Thank you for your attention.